Hello, and thank you all for joining us today for this panel discussion on where Chicago stands on its efforts on reforming the police department and the police oversight system in particular. I want to begin by thanking our moderator, Sharon Fairley, and our four panelists for joining us today. We appreciate that, and we look forward to a vigorous discussion. Before we begin today's panel, I have two short announcements I'd like to make. First, as most of you know, we lost a dedicated and longtime advocate for police oversight reform earlier this year when Harold Winston passed away. Harold was a decades-long attorney at the Public Defender's Office who vigorously represented many clients, but also during his time there, in addition to being a very accomplished chess player, he organized and led a collaborative group of reform groups that worked on police and police oversight and criminal justice reform generally. That was a very effective group for a number of years before we had these other groups enter the space. Harold was a wonderfully generous and effective person, and we will miss him deeply. My second announcement is I'd like to just make everybody aware that Gordon Waldron has announced that he will be resigning as a co-chair of the Chicago Council of Lawyers Civil Liberties Committee this year. Gordon is a former trial attorney at the EEOC, where he worked for decades fighting various forms of discrimination. Gordon was also a founding member of the Chicago Council of Lawyers Civil Liberties Committee and served as its initial chairman and has been chair or co-chair of the committee since its formation over 15 years ago. Gordon has been the council's point person on efforts to reform the police oversight system over that period. And although he will be resigning as a co-chair of the committee, I'm happy to report that he will continue on as a member of the committee, which we're very happy for. We are all immensely grateful for Gordon's efforts over the past 2 decades. And we thank Gordon for his leadership and his work on these issues over that time. Thank you, Gordon, from the bottom of our hearts. With that, I will now turn the floor over to Sharon Fairley, our moderator. As many of you know, Sharon served as the head of IPRA, and then when COPA was formed, she took over and was the first chief administrator in creating COPA and running it initially before she withdrew to run for public office. Sharon has been teaching courses on civil procedure, legal ethics, and public corruption at the University of Chicago Law School since 2015, and she joined the faculty as a teaching member in 2019. Before joining the law school faculty there, she had also held positions in the U.S. Attorney's Office as a prosecutor and with the City Inspector General's Office as general counsel. And we are very lucky to, and she has also, as I understand it, got an article that's either been recently published or is about to be recently published dealing with developments in the civilian oversight space across the country. So we are very lucky to have her here leading this discussion today. With that, Sharon, the floor is yours.
Thank you, David. Thank you so much for that lovely introduction. I'm very grateful to you, and I'm also really grateful to our sponsors, the organizations that created this opportunity for us today: the Chicago Appleseed Center for Fair Courts, the Chicago Council of Lawyers, the American Constitution Society, and the Chicago Lawyers Chapter. So thank you all for this wonderful opportunity to take a moment and step back and engage on the topic of police accountability and police reform. And a topic I think we would all agree has been all too top of mind for this last year. What a year it has been. In the months following the brutal killing of George Floyd, communities across the country have grappled with the seemingly intractable problem of police brutality and the lack of transparency around policing. And although there is still much work to be done, this past year, reform efforts have gained a kind of political traction that might have seemed unimaginable even just 2 or 3 years ago. Police departments have revamped policies. City leaders have actually started talking about, reducing police budgets. They've yielded power to civilian oversight bodies, and state legislators have created new laws to enhance accountability or have walked back older laws that were impediments to accountability. Reform is underway too here in Chicago, as we know, because after all, we had our own reckoning with police accountability following the 2015 release of the videotape of the killing of young Laquan McDonald at the hands of Chicago police officer Jason Van Dyke, who now is serving his 6-year and 9-month sentence for his conviction for second-degree murder and then 16 counts of aggravated battery. But the question we ask today is, how far have we really come since then? Police reform in Chicago seems to be moving at a glacial pace. The city has struggled to meet deadlines set in the consent decree. We have a court-ordered monitor in place and 3 civilian oversight agencies, yet we continue to experience these traumatizing, tragic, fatal encounters between police and young people. So accountability continues to seem somewhat elusive, and frustrations mount even higher when we take 2 steps forward and then take 1 step back. And by that, I'm referring to the safety bill enacted earlier this year by the Illinois legislature and that was signed by Governor Pritzker in February. Now, while not everything that police reformists were asking for had hoped for was in that bill, the bill passed with quite a degree of fanfare. Yet here we are 3 months later, and prompted by pushback from law enforcement community, the legislature has quietly walked back some of those key provisions. So again, 2 steps forward, 1 force backward. So yes, change is happening, reform is happening, but it is quite a struggle. And so here today to talk about it, we have really quite an illustrious panel, a group of panelists here. So let me just say a few words of introduction about them. And then we will engage in a conversation. And of course, you who are here today participating will have the opportunity to ask questions as well. All you need to do is scroll down on your screen to the point where it says submit questions to the moderator. And if you submit your questions, we'll do our best to get to as many of those as possible. Let me spend a minute about these panelists, though, because they are amazing. And each of them has already made several contributions to police accountability for Chicago. Deborah Witzberg is the Deputy Inspector General for Public Safety at the Chicago Office of the Inspector General. She has her roles within the OIG include advising on legal and constitutional matters relating to OIG's oversight of Chicago's police and police accountability agencies. She's leading efforts to screen and review closed police disciplinary cases, as well as evaluations of COPA, BIA, and the police board. Andrea Kersten, the new Interim Chief Administrator of the Civilian Office of Police Accountability. She has been an integral part of COPA's leadership team over the last 5 years, beginning her work at COPA in the legal department as the Chief Investigative Law Officer, and later becoming Chief of Investigative Operations. Andrea has previously served as a domestic violence advocate and ASA in the Cook County State's Attorney's Office. Next, we have Jamie Calvin, founder and director of the Invisible Institute. He's a writer and executive director, and his agency just recently won the Pulitzer Prize for work done on a year-long investigation of canine units and the damage that police dogs inflict on Americans, including innocent citizens and police officers. Mr. Calvin was the plaintiff in Calvin versus Chicago, in which the Illinois Appellate Court ruled that documents bearing on allegations of police misconduct are, in fact, public information. Next, we have Nusrat Chowdhury. She is from the ACLU of Illinois. She has been the Roger Pascal Legal Director of the ACLU of Illinois since January of 2020. In that capacity, she oversees the development and execution of strategic litigation against assaults on civil rights and civil liberties from Washington, D.C. And she leads a team working to advance civil liberties and human rights right here in Illinois. Prior to joining the ACLU, Nusrat served as the Deputy Director of the National ACLU Racial Justice Program. And she's also served as a staff attorney at the ACLU the National Security Project. So we've got some very knowledgeable and experienced panelists to hear from today. They're each going to make a few opening statements before we start to engage into a broader conversation about the topics. And so right now we're going to take a very brief break while we set up the presentations, and we'll be right back to you.
Hello, thanks. Thanks very much, Sharon. I am going to talk a little bit about sort of a landscape view of police accountability and oversight in Chicago, because I think really from a broad view of that landscape, there are some important observations to be drawn about the challenges of the moment and sort of what is most pressingly before us to navigate. I'm going to start very briefly, kind of by way of approach here, something that you all are the choir on by virtue of your interest in your being here today, which is sort of why reform matters. I think, Sharon, as you sort of talked about in your opening remarks, we continue to see the tremendous potential for harm to individuals and to communities when policing goes wrong. When something bad happens, we sort of continue to see the painful aftershocks of that. We talk and think a lot about, to borrow a notion from the social science literature, the sort of synergism of plagues, that the communities in Chicago which are most impacted by policing and by problems in policing are also those communities which are most vulnerable in lots and lots of other ways. And so I think, the equity impacts of policing and therefore the equity impacts of police oversight and accountability are an increasingly sort of urgent and salient part of this conversation. The financial costs of police misconduct are certainly, from a taxpayer and a good government perspective, a really important piece here. In 2019 alone, the city of Chicago spent $48.8 million directly arising out of police misconduct. I think we also, in thinking about affected communities and people impacted by policing, we have members of the police department. We have 13,000 people in uniform who are in the position of making very high stakes decisions for themselves and for the people they encounter under very dangerous and very high stress conditions. And then, against the backdrop of a summer during which we are seeing staggering violent crime numbers, we are really concerned about and interested in the effective performance of core law enforcement functions, how well the police department is doing those things that it can do to keep people safe. And we think and talk a lot about the extent to which the quality of the relationship between the police and the community has real public safety implications. The notion that everybody in uniform and out is safer when people trust the police. So the present moment in police reform in Chicago certainly feels and is a critical and urgent one. I think it's important to situate the moment we are in now sort of against its historical antecedents. And this is true for a couple of reasons. One, there's a little bit of the notion here that those who forget history are doomed to repeat it, that there have been some lessons learned, which we would be well served to keep in mind. I think there's also, there's an opportunity to ballast what I think has been a problematic inclination here and elsewhere in recent years when it comes to police reform and police accountability, which is a sort of reactive, crisis-driven approach. Something very bad happens. Sharon talked about the Laquan McDonald shooting and the release of that video as sort of a watershed moment in Chicago, a catalyst moment in Chicago, certainly the case. I think there's a good governance problem with an inclination to have these successive reactive approaches spurred by individual crises. And I think, as I say, there's an opportunity to sort of ballast that inclination by keeping the broader brush of history in mind, sort of avoid like an ahistorical ping-ponging of reform efforts. And so I won't go through all the details here. I would say the report of the Police Accountability Task Force is a very good source for some of this history if folks are more interested. But broadly, the observation here is that what was then the town of Chicago was authorized to establish a police force for the first time in 1835. And by 1898, there were efforts at kind of programmatic reform, efforts to reform the police department. And so from 1898 forward, there have been these periodic, large-scale, broad-reaching efforts to improve the operations of the department. And I think critical to note that at least in the sort of 20th century era and forward, many of the specific concerns that some of those enterprises undertook are ones which look an awful lot like the ones we talk and worry a lot about today. So, that brings us up through sort of the modern era of police reform efforts in Chicago. The Laquan McDonald video was released in 2015. There were changes in the municipal code in 2016 related to the work of the Police Accountability Task Force and the Department of Justice pattern and practice investigation, followed by the litigation in Illinois versus Chicago and the implementation of the consent decree, which took effect in 2019. And so here we are in 2021, and the accountability and oversight landscape in Chicago, kind of coming out of that long road, is a really crowded one. And there's plenty of work to be done, for sure. But I think that we are faced with a challenge here in the crowdedness of the landscape and the overlap of some of the mandates and efforts of the various institutions at work. You talk about this sometimes as sort of a bowl of spaghetti that really bears some untangling. And I think that if we could navigate that successfully, it would enable everybody working here in the space to be more effective. So I'm going to try to be brief here. As a recovering trial lawyer, it doesn't come naturally to me, but I will try to be brief. There are lots and lots, this is sort of an alphabet soup of acronyms of agencies working in this space here. The Chicago Police Department has internally both what are sort of investigative and evaluative oversight components. We have the Civilian Office of Police Accountability, and you'll hear more from Andrea about their work. There's the Chicago Police Board, which is on paper charged with a very broad array of duties, including adjudicating the most serious of police disciplinary cases. They also are empowered by ordinance with policy and rulemaking authority. They have contemplated roles in lots of other processes. The independent monitoring team is charged with implementation, overseeing compliance with the consent decree. We'll talk more about the consent decree in just a second. Here at the Office of Inspector General, multiple components of the office are involved in police oversight and police accountability. We conduct some frontline misconduct investigations ourselves out of our investigations section. Our public safety section is devoted specifically to oversight of CPD, COPA, and the police board. And then, of course, there is, as you all know from the news, pending before the city council, this notion of a new civilian oversight body, which would have, some combination of duties and powers. That's a lot of people working in the space, and so it sort of leads us to this question of who does what, and who is, best suited to conduct which kinds of work. The overlaps here are important, and I think it's useful to think, as I say, about both kind of investigative and evaluative work. In the kind of investigative space, there is the Bureau of Internal Affairs, COPA, OIG Investigations, and in the evaluative space, CPD's Office of Constitutional Policing and Reform. COPA is empowered by ordinance to do policy work and look at patterns and practices of misconduct. The independent monitoring team obviously has a broad mandate under the consent decree, although we'll talk about that in a second. And OIG, our public safety section, has an ordinance mandate there as well. So just quickly to talk about the consent decree. So the consent, this is a 799 paragraph document. It's divided into 9 subject areas of oversight of the police department and the accountability agencies. The monitoring team has an associate monitor responsible for each of these subject matters that are listed here. And I'm sure there'll be more discussion of this here today. There's an awful lot that's covered in 799 paragraphs, but the consent decree is not a reform omnibus. It doesn't cover the entire landscape. In terms of compliance and where we are with compliance, We are coming up on the end of a reporting period. There'll be another compliance report out this summer from the independent monitoring team. As of the issuance of the last report, the IMT had looked at assessment of 315 of the paragraphs in the consent decree. The city had demonstrated some at least minimal level of compliance with 154 of those and met 17 of 43 agreed upon deadlines. So, I think what this calls for is thoughtful navigating of a crowded field. And so as we think about increasing the pace of reform and the effectiveness of the efforts underway, I think this is really critical, sort of thinking about how we navigate a crowded field. And I think the way there are two ways to think about that, and that has to do with kind of staying in lanes and playing to institutional strengths. So where there are sort of theoretical or on paper overlaps among these many entities, this requires some, as I say, some staying in lanes and some playing to institutional strengths where all resources are limited, right? So a couple of considerations as we think about which entities in the field are best suited to take on a variety of these issues. Independence is a critical thing to think about. The various entities here have different levels and different kinds of independence from City Hall and from the police department. When we think about investigations, there are questions about sort of personal jurisdiction, who an agency is empowered to investigate. Subject matter jurisdiction, COPA, for example, has specifically allocated subject matter jurisdiction in the municipal code, and legal capacities. So we think about, for example, subpoena power. OIG and COPA are empowered to issue administrative subpoenas. The Bureau of Internal Affairs is not. So there are sort of different legal capacities here, which bode for different agencies handling different matters that come up. When we think about programmatic inquiries and policy recommendations, that is an area of, I think, particularly multi-layered overlap. And so, we think about the scope and contours of legal authority and access to an analysis of data. OIG, one of the tremendous kind of structural advantages of the public safety section being situated within the larger Office of Inspector General is that our office's kind of citywide enterprise spanning jurisdiction and our access to data, back-end access to data from a broad variety of city sources that really informs some programmatic inquiries into policing and police oversight. I think also critical to understand policing as part of an ecosystem. The police department does not operate in a silo. It doesn't and shouldn't operate in a silo. And many of the problems that I think are facing the criminal justice system and the police department are multi-agency problems, and they therefore require multi-agency solutions. And so when those issues come up, I think really important to think about their being handled in a way and by, in a way that reflects this multi-agency sort of ecosystem by entities empowered to oversee all of the actors in the space. So in terms of data, I just wanted to flag this for people, the OIG Information Portal. We can talk more about this, but there's a huge amount of city and public safety specific data available publicly on OIG's dashboard. I think, we think a lot about the oversight responsibility of sort of arming stakeholders with information. The demystification role and sunlight as antiseptic are all things that I think are critical across this crowded landscape. So I want to make sure that the information portal is on everybody's radar. But I'll stop there in terms of sort of the overview, the crowded landscape and how I think it's best to navigate it.
Thank you so much, Deborah. That's really helpful to get us started out and sort of frame the situation that we're in. And I really appreciated how you provided that historical perspective, because we in Chicago are the poster child for what I call the scandal reform repeat approach to, reforming our police accountability structure. Pretty much every piece of the system we have that's in place right now was formed in reaction to a scandal, right? The Chicago Police Board was formed in reaction to the Summerdale scandal in 1960. OPS, IPRA, COPA, all of it. So thank you for providing that as a backdrop to the conversation. And right now, I'd like to invite Ms. Kersten to chime in and give us her thoughts on, what's gone well and what are some of the opportunities going forward. So we're going to take a quick break and get Andrea set up to address us.
Thank you so much for the opportunity to talk a little bit about the current state of affairs at COPA, the Civilian Office of Police Accountability. I appreciated a lot of Deborah's remarks because I think she did an excellent job in sort of framing what she described as the bowl of spaghetti that serves this issue for our city, right? The very complicated web of oversight. But the role that COPA plays is actually pretty straightforward with most respects. We are the largest portion of the investigative capacity for police misconduct allegations. And as was alluded to previously, our ordinance in the Chicago Municipal Code specifies specific areas of jurisdiction, such as excessive force, all discharges of an officer's firearm, Fourth Amendment allegations, coercion, verbal abuse that's bias or race-based or gender-based. So when I'm trying to describe it to folks, I typically say most of our jurisdiction is kind of that front-facing, those allegations that are very complaint-driven from citizens, whereas the Bureau of Internal Affairs at CPD, they handle a lot of things that are internal to the department. So we have at COPA typically a lot of the cases that end up sort of in the news, right? The things that the public hears about, that people are outraged by, a lot of those end squarely in our laps to try to make headway through the complex, legal standards and application of general orders that each and every one of these cases deserves. So where are things with COPA right now? As I was introduced as the interim chief, I can say that here we are, a 4-year-old agency on the verge of having our 4th chief administrator. So that's particularly a challenge. We've had a lot of leadership that has changed this agency, but throughout that time, we've had people such as myself who have really tried to continue to invest in the work that is ongoing here. The top of the program, the remarks about sort of how our city ended up where it is in police oversight right now. Certainly the murder of Laquan McDonald prompted a lot of this change, and that outrage over that incident was kind of a clarion call for people such as myself to come to this issue and to stay and to take root and try to make progress, which can be slow at times. So for COPA, we came into being in 2016, but we brought along with us the legacies that were kind of there before, right? We brought the caseload that we started with from IPRA. We brought a lot of existing baggage as far as public perception and credibility of what this organization can do. And so we spent the last 4 years really trying to set ourselves apart from that. And I think that work has been robust. It has been hard at times. Some of the most significant things that we have done to really set ourselves apart are about our training, about the COPA Academy that was created ultimately by Sharon and perfected over the last 4 years, as we've had multiple iterations of incoming investigative staff come to this issue because they want to be a part of this change. So really trying to instill that we have the right lens and perspective for how to look at these issues, as well as the technical skill and ability. Another big difference and thing that we emphasize at COPA is the involvement and the engagement of our legal department. These investigations are administrative investigations, but rooted in law and application of facts to law. So wanting to really make sure that our attorneys don't just handle the agency's legal problems, but are actually embedded in the investigative process. And that's really, really elevated our ability to weigh in on difficult use of force cases, particularly use of deadly force and fatal shootings to a degree of success that had not always been able to be achieved before. But really, in addition to that work as well, as Deborah also mentioned, we have the ability to have policy say. We have the ability to say, what are our cases showing us? Because at the end of the day, data drives a lot of this conversation, but we're the people having the most contact with impacted parties as an agency. So we're hearing that anecdotal, direct information from the people who live in communities that are policed differently. And so to be able to have a voice in that conversation that's driven not just by data, but also by our direct encounters with people, with our fellow neighbors and citizens, it's a powerful responsibility and something that we are working to further develop as an agency. This last year, we actually stood up the Policy Research and Analysis Division. We devoted a Deputy Chief of Administration to that position to make sure that that was led by someone with the right lens and authority to speak on behalf of the agency in that space. So we are working all the time to kind of live up to the potential of what I know this agency can be and what it was envisioned to be. But those challenges are ongoing. And I think something that is so important for all of us that are engaged in this work is certainly independence. And COPA's independence is something it fought fiercely for in its creation, both from an economic standpoint, from a political standpoint. But something in the last 4 years that I think I've come to observe and realize is that independence doesn't have to mean isolation. And so wanting to find ways to make sure that we recognize we're part of this broader network, and that our work, to the extent it can be shared, needs to be shared. We need to make sure that we can make public the things that have been successes for the agency. What I know about police reform and its progress, and what's seemingly a slow progress at times, is that it took us 186 years to get to where we are with the history of the Chicago Police Department. And COPA certainly can't solve it alone and wasn't going to solve it in any amount of years, but we are working towards that progress. I'm certain of it. I see it in the cases. I see it in the staff that's coming in our door. And it is something that's acknowledged by people that we interact with, external stakeholders, whether that's our partner agencies that have to rely on our work, or individuals that say, hey, you listened, you heard, you believed, and that matters. So that's the kind of progress that I'm excited to keep continuing. And, you know, for as long as I'm in this role as the Interim Chief Administrator, we are working diligently at this agency to continue that momentum and to be ready to embrace whatever the next chapter for COPA is in the broader system of police oversight for Chicago. So thank you.
Thank you, Andrea. Really, really interesting to hear about the emphasis that you guys are placing on these important issues for COPA, and to see how it has developed over the 4 years that it's been a player in this space. So thank you for that. I'm going to next turn the mic over to Mr. Calvin. Do you want to unmute?
Thank you. Can you hear me? Yeah. Thank you, Sharon. So I'm going to speak a bit about the juncture we've reached in the reform process with respect to transparency from a civil society perspective. And I'm tempted to say that transparency should be the easy part of the larger reform effort. That in a sense, it's low-hanging fruit. And I mean that in a couple of different ways. One, as Sharon mentioned in her introduction, it's been established as a matter of law in Illinois that documents bearing on allegations of police abuse are public information. So proactive policies that facilitate access to this information don't require changes in the law. It only really requires political will to make it happen. I think there's also a sense in which transparency is easy in that it's one of the things that can be done early in the long haul of reform. This isn't a matter of really reconceiving and fundamentally altering complex institutions and bureaucracies. It should also be enacted early in the process because obvious point is foundational in the sense that it provides citizens with access for the information that they need to be effective in performing their roles. Also, and I think Sharon and I had conversations about this at the outset of the IPRA-COPRA evolution. It's one of the ways available to institutions struggling to establish their legitimacy, their credibility, their worthiness of trust. This is one of the tools that's available to demonstrate that you're worthy of trust. It's a way of saying, whatever else, we won't lie to you. And I think, I've said this in print, transparency is a sort of a sterile word. It's useful. It's a useful concept, but it's got a kind of sterility. I mean, what we're fundamentally talking about, especially, in this city with the experience of the Laquan McDonald implosion, is, we're talking about government exercising information control in order to sustain a preferred official narrative. And a simpler, commoner, blunter word for that is lying. So really, at the end of the day, talking about a kind of candor and openness on the part of government about acknowledged problems that we haven't, that we're grappling with. And so there's a more than, there's great practical importance in the information being available, but I think there's profound symbolic importance as well in transparency as a principle of governance. And so we've had this interesting opportunity because the law, by virtue of the Calvin versus Chicago decision in 2014, and then the consolidation of that decision over a period of years because of a pretty sustained set of legal counterattacks by the fraternal police. We now have a kind of bulwark, a very solid, consolidated legal basis for transparency going forward. And the question is how to build on that more proactively to create efficiencies, ease of access to information for all parties, for citizens, for the incarcerated, for litigants, for journalists, for researchers, above all for the general public. And so I have to say at this juncture that it's mystifying that this sort of proactive transparency agenda has encountered such resistance on the part of an administration that was swept into office with a reform agenda. A mayor who as a candidate spoke of the critical importance and foundational importance of transparency. That it's not only a failure to proactively advance the possibilities of a more robust transparency regime, but active resistance to it. And it's, as some of you may know, and I have been kind of dragged into this world by younger colleagues and people with competence that I don't have. After we prevailed in the Freedom of Information Act decision, the Invisible Institute, my organization, undertook to create the Citizens Police Data Project, a public-facing database that houses the sort of police disciplinary information that became available as official secrecy gave way. It was never our intention to perform this function in perpetuity. We saw it as a useful tool in itself for various subsets of the population, but also as a sort of demonstration project of what could be done with this information if it were really well curated, if active pattern analysis was done, but it was always meant to invite adoption by government. And in recent months, we've had a very constructive process, principally with the Office of the Inspector General and under the auspices of Alderman Wagenspach in crafting an ordinance that would build on what the OIG has already created in its data portal and create a kind of, we think of it as a library, a public repository of this information that people could readily access without going through the kind of Rube Goldberg contraption of FOIA as it exists right now. When we prevailed in the Calvin decision, in effect, every citizen got a library card that said you could take out a certain number of documents from the library by way of FOIA. What we are proposing and attempting to craft now is an ordinance that would in effect throw the doors of the library open and build a robust and ever more robust public repository. So this, has been, I won't go through all the twists and turns of the legislative process, but, we went through a succession of different phases of response from the administration of, first really just an unwillingness to engage multiple invitations to work together to craft a realistic, cost-effective way of doing this. Then as the ordinance process gained traction, fierce opposition on the part of the mayor to the draft ordinance that had emerged, and the dissemination of really quite extravagantly absurd misinformation about the cost of the ordinance that was later impeached by the City Council's Office of Financial Analysis.
So Jamie, this is really, the topic of, the issue of transparency when we look back at this year in particular, right? It's like we know that, we've had these really egregious instances of force and brutality, and those are bad enough, but it's like layered on top of that are these issues with lack of transparency, right? We have the delay in the video release of the incident involving Daniel Prude. We have, information around coming out initially around the incident with George Floyd that mentioned nothing about somebody standing on his neck. We have misinformation going out about Breonna Taylor, right? And so transparency has really, really become such an important aspect of the challenge that we're facing here. And so perhaps with that, maybe Nusrat, you could chime in here and talk a little bit about your work and kind of how you see this whole thing playing out.
Absolutely. Thank you, Sharon, and thanks to all for joining this conversation. I came to this work in Chicago having worked on racial justice and policing issues in multiple cities across the country. And I think what strikes me here in Chicago is the promise of tools for change, but then the tremendous challenges and hurdles that community members are facing and actually making that change realize a difference in the policing that impacts their lives. And so taking a step back, we've talked a little bit about the consent decree, but I actually want to situate what that really means. This phrase, the consent decree, often is talked about in really legalistic terms. That's difficult for human beings in the city of Chicago whose lives are impacted by policing to understand what it is and how it can be a really critical tool if the city is willing to let it be. The consent decree came about because of patterns of excessive force against people of color, people with disabilities, and other marginalized groups in the city of Chicago. And 3 lawsuits helped make it happen. The first is a suit by the Illinois Attorney General against the city of Chicago, another suit by a range of community organizations represented by lawyers at Northwestern, University of Chicago, and the MacArthur Justice Center, and then a third lawsuit by the ACLU of Illinois on behalf of community organizations like Communities United, One North Side, Next Steps, and Community Renewal Society. And these 3 suits essentially led to the city to agree to an agreement, which Deborah outlined is very extensive, governing 9 areas of reform, but not occupying all policing all the time, but really setting forth very clear principles on impartial policing, limiting force, de-escalating, promoting more dignified and respectful interactions with human beings, including young people in the city, people with disabilities, people in mental health crisis, and communities of color, and a range of other changes to promote accountability and transparency. And so that decree can be enforced by the Illinois Attorney General, as well as by a coalition of 14 community organizations that had brought those 2 other lawsuits. And in return for giving up those suits, the coalition of community organizations gets a right to go to court when the city of Chicago is failing to abide by its obligations under the decree. And I want to set up a little bit of that background to explain that this is one tool amongst many spaces where there's active pushes for police reform, including through protests on the street, which are critically important. And the 3 biggest challenges I see right now to really the city embracing the consent decree as a place for moving policing away from a direction of the patterns of excessive force against people of color and people with disabilities are the following. The first is that it's an overarching principle of the consent decree and of constitutional policing in general that police engage with directly impacted people because they have expertise and knowledge about the problematic practices that lead to these patterns of violence and biased policing, as well as some of the solutions. But what we've seen time and time again in the past years is that the city is approaching communities, including groups that have been involved in this fight for years and decades, without that approach to actually wanting to listen and change and really engage with their ideas and expertise. And two specific examples of that. The city, upon recommendations from the monitor who enforces the consent decree or monitors compliance with the city's obligations under the consent decree, recommended the creation of working groups. And the city created a couple of working groups, one on use of force, one on the issue of police and schools. In both spaces, we saw community members with real expertise, both professional and personal, making concrete recommendations to the police and really being dismissed. The use of force working group last fall issued multiple recommendations, very thoughtful ones, after hours of sitting down with police and redlining policies, really talking and speaking and thinking intentionally about what those policies should look like. And after one of their meetings, in a press release issued just minutes later, the city rejected almost everything that they had recommended. And people can tell when the city is coming to them with a real openness to listen and change. And people can also tell when they're not, when community engagement becomes a checkbox. And too often, community engagement has become a checkbox, and one that's entered into really late in the process, once policies are almost formulated, and getting that input is too late. We see that time and again. And I think with the police and schools working group, what was notable is that police in that people, community members in that working group were saying repeatedly, we really need to involve youth. If we're talking about the issue of police and schools, we need to bring in the perspective of youth. And they offered a number of recommendations how to do that, and the city rejected them. So the voices of young people weren't incorporated into those conversations. So that's one important and significant area of challenge. A second is that the city is consistently treating the consent decree as a ceiling, not a floor. And it's a ceiling that continues to fall lower and lower. Each time there's a crisis in the city, and the city chooses, as Sharon mentioned, to create a separate avenue of inquiry rather than, again, going to the communities that have been engaged in this fight and about policing that impacts their lives. And so, for example, Sharon mentioned the disclosures of videos. The city and the nation was shocked back in December when we saw the video of the raid on the home of Anjanette Young, a Black social worker who was held naked at gunpoint by male officers while she repeatedly brought to their attention that they were in the wrong home. And she was clearly in distress, and that incident lasted a long time. That issue has been on the city's radar for years. It did not just come up with the raid of Ms. Young. The coalition enforcing the consent decree had actually notified the city of a pattern of wrong raids impacting Black and Brown people in August of 2020, months before the video of that raid became public. But the city's response was to not engage with the coalition at all, and instead to set up a separate system for revising its search warrant policies rather than actually engaging with communities that had been raising this problem and raising the call for a really long time. We've seen a similar problem with foot pursuits. Foot pursuits and foot chases by police we know are deadly and dangerous. It's been an issue consistently from the beginning of the negotiations concerning the consent decree. And it took years for the police to actually come up with some kind of foot chase policy. It wasn't until March of this year when, because the monitor enforcing the consent decree recommended a policy to actually restrict this dangerous practice, that finally the city took pen to paper. And we all know that recently Anthony Alvarez and Adam Toledo were killed in tragic incidents involving foot chases. And we're left as a community wondering if that would have been different had the city actually taken the initiative to do something far earlier, which it could have done because community organizations were calling for it. And the third largest challenge, I think, is that we are watching in real time as people's call for changes to violent and racially unjust policing are met with violence against protesters who are sending those messages out. And we saw this last summer with the police use of baton strikes to the head, police use of OC spray, police retaliation against journalists in real time in response to protests on violent policing following the murder of George Floyd. And the federal court in the consent decree appropriately convened 2 days of public hearings involving 58 witnesses. I believe more than a dozen people submitted written testimony, and the court heard the testimony of people who had experienced that kind of violence and witnessed that kind of violence, which disproportionately impacted people of color. So at the very moment that the city, not just the CPD, but the city itself, is subject to a federal consent decree that is supposed to rein in patterns of violent and racially unjust policing, what we see is the use of violence against people who are calling for change. These are 3 tremendous hurdles. It is up to all of us to see what we can do to address those hurdles. And I think part of what gives me hope is that there are so many communities that are engaged in the consent decree process and in other processes calling for change.
Thank you so much, Nusrat. That was really, really helpful to hear that perspective. And I want to open to some discussion now. And I think I want to start. First of all, let me just remind everyone that if you'd like to submit a question to the panelists, please scroll down on your screen and click on the button of submit a question to the moderator, and we'll try to get to those questions. But for the first, I think I want to open it up with a quite broad topic, which is, Nusrat, you were talking about how, that the department was slow to update or create a policy on foot pursuits, for example, or slow to really use policy to address this practice of improper searches that were being done. So I want to start with a question of, how is policymaking actually done here in Chicago? And we know we've already heard from both Deborah and from Andrea that both of their agencies actually have the power to make policy recommendations. And we've seen, communities across the country really demanding a more direct say in policy that drives the policing in their communities. So how does it work here? And is it working the way it should?
I will say, is it working? Probably not, is the best answer. There are many mechanisms and many agencies with touchstones in the policymaking process. There's, I think, an intersection here with sort of the will to reform. We talked a little bit about, in thinking through different agencies, we talked a little bit about sort of the contours of legal authority. One of the distinctions here is whether the police department is obligated to respond in a public and in written way to policy recommendations. So that is a distinction between OIG and COPA. So the municipal code requires the police department to respond in writing to recommendations from the Office of Inspector General. That is designed as a sort of, right, again, with the notion that information in the hands of the stakeholders is most powerful. That mechanism is designed to sort of make some public accounting on policy questions. The other, I think, critical mechanism within city government with respect to policy is the Public Safety Committee of the City Council. Again, the municipal code requires the Public Safety Committee to hold a subject matter hearing on any OIG report, which contains policy recommendations and the department response. It has been our experience that even when sort of that legally required threshold is triggered, the Public Safety Committee hasn't done so. So I think we are missing real opportunities for the city to call on the carpet those responsible for formulating and implementing revised policy.
Anybody else want to address that issue?
I would just add, I certainly agree with that sentiment that we're kind of missing the actualization of a lot of the very informed perspectives. This is one of those areas where I think that COPA and PSIG actually kind of dovetail nicely with one another in that often our policy recommendations, as I mentioned before, are coming from specific cases that we've investigated. And then to have the Office of the Inspector General have the ability to take that more landscape view approach to an issue that we're seeing over and over again bear out in cases, I think is the right way to address these issues. Now, how action gets taken is sort of a different question altogether. And I think what Nusrat was saying about community engagement is it's of paramount importance. When we truly put the power in the hands of people whose lives are most directly impacted by these issues, we get better results. And I just wanted to highlight that something that COPA has been able to do in its own community working group process is very similar with the consent decree compliance and how we evaluate our policies internally and how we change them. We had to put together our own community working group, much like what Nusrat described with CPD, except with quite a different outcome. We wanted answers, even when they were inconvenient ones, and we wanted to be able to implement that information in a way that was meaningful and informed our work, improved what we're doing. And so getting CPD to a position where they're willing to hear the hard truths and do something about it is sort of, that's where we're at. And that's what we're trying to find inroads towards with respect to policy, for sure.
Thank you for that. So I kind of interrupted Jamie when we were on the topic of transparency. So I'd like to get back to that if I could, and perhaps he might want to comment on this. But we here in Chicago have had this transparency policy in place for a few years now, where it's the policy that we release video material and certain other types of documentary material related to critical incidents within a certain time frame. How do we feel that the implementation of that policy is working? Is it helping?
Yeah, so two points. One is the broad point, which is, if we think about, you were making this point about George Floyd, Breonna Taylor, other incidents across the country in this most recent period. If, the Laquan McDonald narrative has, for better or worse, been the kind of framing narrative of our public life for these years. And the public response and the enduring response and the enduring issues of institutional credibility arise not just from the atrocity of the execution of a child on the streets of the city, but the overwhelming fact that the city knew everything we know about the case today within hours of the incident and managed that information through an ultimately sort of catastrophic effort to maintain an official narrative at odds with the facts. So we're still kind of living inside the crater that was created by that implosion, and so that's critical. In response, we've had the revision of the first the 60-day policy, and the more recent revisions. I think that the challenge, and we've seen this with several different cases, I think particularly of the Harith Augustus police killing in the summer of 2018, where in defiance of COPA, or at least to the displeasure of COPA, the superintendent released video within less than 24 hours in order to correct public perceptions, as he saw it. I think the thing that's challenging is that transparency can actually be deployed as information control if it's not really well formulated as policy. And I'm not sure we're there. So selective release of information can be as much a tool for maintaining an official narrative at odds with known facts. So there's more work to be done.
So perhaps I could ask Andrea to talk for a minute, because Andrea, it's your agency, correct, that's responsible for implementing this policy. Could you tell us a little bit about how it works, and just so that we understand, some of the challenges that are present when you are grappling with the issue of what's being made publicly available and when.
Absolutely. So yes, COPA is responsible for implementing the City Hall's video release policy. And this policy is the same policy essentially that existed, came into effect in 2016. And it requires the release of all, not just body-worn camera, but all video. So that's private video, in-car camera, any video footage, any audio recordings, so that's 911 calls, et cetera, as well as written department records, so police reports, tactical response reports. So a very robust amount of information about any officer involved shooting. So anytime an officer shoots at a person, whether or not anyone is struck, any death that's an officer involved fatality, whether that's a vehicle pursuit or a death in custody, or any other use of force that results in serious bodily harm. So it's a wide range of incidents that trigger this policy. And then the policy allows for our agency to have 60 days to release that material. And when this came into being in 2016, as we keep talking about, and I think it's important to remember the history of it, was obviously in the wake of the Laquan McDonald video and the city's lack of transparency around that and the intentional withholding of that information. But when this came into effect in 2016, it was revolutionary as far as what the nation was doing with respect to video release. There wasn't another city in the country that was saying, hey, all of our video, all of our body-worn camera, everything we've got on this shooting is going to be made public in 60 days. And so I think Chicago felt pretty good about where it was at. And as an agency that was tasked with actually implementing this, I can tell you a significant amount of work goes into any one of these, because if you've spent any time on our website looking at any of these videos, or know anything about the way the police department responds, particularly to an officer involved shooting, it may be one unit or 2 or 3 officers involved in a shooting. But then when the radio call goes out about what the nature of this event is, the zone is flooded with officers, and each one of them has a body-worn camera. So there are hundreds of hours of videos that we have to go through in each and every one of these incidents in order to kind of cull the actual video and evidence that captures the incident that is triggering the policy to be public. So there's a lot of work. We have an interdisciplinary approach at COPA. We have members of our legal team. We have members of our investigative team. We have members of our IT team to do all the necessary privacy redactions, et cetera. And most importantly, we have our public engagement people. I think something that folks probably don't realize about what COPA does is every time we release a fatal video like this, we meet with the family to the extent they want to. We show them that video in private, in our office or at a place that's convenient to them, in order to make sure that they have the opportunity to have some level of dignity and respect given to their experience prior to having that released to the world. So we're constantly balancing sort of impacted families' interest versus public interest versus investigative integrity as well. I mean, that kind of gets lost in this conversation too. We'd like the opportunity to conduct as much of our investigation prior to these videos disseminating, but I think we live in a world where we're realizing we can't take 60 days to make public this information. So COPA is eagerly looking in 2022 to actually devote dedicated resources, not borrow from our investigative and legal and IT departments, but create a team that is dedicated specifically to not just video release, but FOIA, which is another big part of public trust and transparency, as well as the mayor's executive order. Nusrat was talking about the Anjanette Young case earlier, which I think everyone is familiar with, unfortunately, but perhaps importantly. And out of that came the mayor's executive order, which said, hey, anyone that has an incident with police that's captured on body-worn camera that has a complaint about it is entitled to that video. So again, making sure we have the resources to get people that information is key. We can have all the policies and the executive orders and all of the best intent in the world, but without properly resourced agencies to fulfill these requests on the kind of timetable that I think they deserve and that the public is clamoring for, we're not going to have much success. But I am optimistic about this moment for our city, and particularly this moment surrounding transparency. And Jamie, I got to say, I've been thinking a lot about what we want to call this unit, and your notion that transparency is essentially trust, I think, is a lot of the answer to what that needs to be called, because it is at its core about trust and helping our city trust that we're doing the right thing.
Thank you. Thank you, Andrew. That's really helpful. I mean, yes, so transparency has just become just such a core value in the context of police accountability. And when you look at what's going on around the country, there are actually cities who have placed such value in transparency and the theme of it, the word of it, that they've actually used the word in the name of the entity they create. Like, for example, creating an entity called the Office of Police Accountability and Transparency. That's how important this has become. So thank you for that. We've got a lot of really excellent questions coming in. So I'm going to ask just one more before I get to the questions from the audience and from the attendees. So this next question that I'd like to ask for you guys is that police reform obviously doesn't take place in a vacuum, right? There's a legal framework within which all of this has to operate, which can sometimes create constraints around whether certain reforms that we really want are actually legally possible. So, for example, right, we know that there are provisions in collective bargaining agreements that sometimes are an impediment to accountability. We know we have state law also that can be put in place. So what are the challenges from a legal perspective that we are seeing right now in terms of, our ability to achieve reform? We know that there are actually some paragraphs in the consent decree that are not really possible, for example, unless we change these collective bargaining agreements. So how big of an impediment are they, and are we making any headway there as well?
I mean, I'll jump in, Sharon. I think that actually political will is the bigger impediment than the legal agreements, because I really think if the political will is there, the city takes positions on laws in Springfield. The city takes positions in collective bargaining agreements with police unions. The city takes positions in the conversations around what change is needed in the consent decree. And I think if the city comes to these spaces with the desire to change and to truly reflect on what's broken and not working and leading to violence and racial injustice, the city can make decisions that will change outcomes for the people of the city. And instead, too often what we're seeing is the collective bargaining agreement or the consent decree being referred to as the limits for the change that can happen. Now, in the consent decree itself, there is a provision that says that the city needs to make best efforts to ensure that collective bargaining agreements that it enters into are effectuated in a way that leads to implementation of the consent decree. So best efforts is not must, best efforts is not shall. So again, the power is in the hands of the city to make some of those changes. I mean, one of the important changes that happened in Springfield this last fall, which was after years and years of work by community members who had raised this as a problem, was elimination of the requirement that a person complaining about police misconduct sign a sworn affidavit. And as should be obvious, this is a huge deterrent to people's ability to report police abuse, because a lot of people don't have the access to sworn affidavits. They're intimidated by the process. They may be subjecting themselves to prosecution for perjury if they make a mistake. And all of these things can chill people from actually complaining about misconduct in their lives. And of course, some of the collective bargaining agreements that exist right now, and particularly those in Chicago, are incompatible with the removal of the affidavit requirement. So it's really on the city in its new negotiations to make sure that agreement is gone, that the state law is what prevails. And I think it's just an example of how each of these spaces intersects with each other. And one of the common entities in these spaces is the city of Chicago. And so the outcomes in each of these spaces can be really different if the city is coming to these spaces with the intent at removing obstacles to accountability.
I just want to add to that quickly. I think the notion of looking for ways to remove obstacles, I think is a really good framing for this. And I certainly agree with the premise that there are legal constraints. I mean, there are sort of external constraints on some of this work. There are, however, also opportunities through and around some of those constraints. And so Nusrat talked a bit about the affidavit requirement. That's a hugely important issue with respect to the kind of accessibility of the disciplinary system to impacted people. We've reported on this publicly. There has long been a mechanism to override the affidavit requirement. And so there has been a requirement for a sworn affidavit, except that there has been a mechanism by which the investigating agencies, primarily BIA, the Bureau of Internal Affairs, and COPA, could override that requirement. And we've looked at that and found that mechanism was really critically underused. And so even in spite of that constraint, where there have been opportunities to, even in spite of those constraints, pursue meaningful accountability, those opportunities have not sort of been seized upon. And so I think as we think about the legal constraints and the legal landscape, it is simultaneously important, as Ms. Rutt says, to think about opportunities to navigate through and around them.
Thank you, Deborah. That's really helpful and important to keep in mind. Absolutely. So we do have a number of questions. There are a couple of folks that are asking, we have these new policies that we have just put in place, the foot chase policy and then the search warrant policy. And the question for you all is, have they gone far enough?
No, they haven't. Unfortunately, a couple of things just to highlight with the foot chase policy. The interim foot chase policy was promulgated without community input, and I think that's important to underscore. CPD is now engaging with communities in some way, and I think we're waiting to see whether this foot chase policy is going to change significantly, because I think there are some really major concerns with it that community members are already raising. One is that there are lots of standards in there that are very vague and hard to understand. And I think the core goal of a policy is to provide clear and easy to understand rules that officers can implement in real time. And I think we all know from the videos of the horrific shooting and killings of Adam Toledo and Anthony Alvarez is that officers are engaging in foot chases, often with adrenaline running, and they need to be able to implement what they've learned in policy realistically. And a policy that is this vague and mushy doesn't enable that to happen. And I think another overarching point to underscore is that it still permits foot chases for many minor offenses, things like underage drinking, gambling, and possession of drug paraphernalia. And what it doesn't do is underscore that foot chases are inherently so dangerous that they should be off the table for those kinds of minor offenses, and in most circumstances, unless they are truly necessary. And finally, I'll just say that the foot chase policy doesn't require public reporting on this theme of transparency. The CPD is not required to report to the public the number of foot chases, the number of instances using force and deadly force. And it also doesn't require and ensure that every single foot chase is documented with the reasons as well as the risk assessment an officer engages in, so that a supervisor later can review and make sure that that foot chase was not unwarranted. And all of these are really significant problems.
Thank you, Nusrat. So we know that we have a couple of ordinances on the table to create yet another oversight entity for the city of Chicago for a new police commission, and part of that, part of the mandate of that particular body, if in fact it is stood up, would be to take on some of the responsibilities that now rest with the mayor. So how do we think about how that adding that to the mix here is going to have the potential to improve things?
I think the potential to improve things there has to do with providing an opportunity to ensure that policymaking and sort of leadership selection and so on are simultaneously informed by both lived experience of people in the community and sort of technical and subject matter expertise of people doing the work. I think both of those are necessary ingredients to good policymaking and good leadership selection. I think, the challenge is in sort of calibrating those inputs appropriately. But that, in my mind, is the opportunity presented by the sort of civilian oversight body that's contemplated.
So there's a question around the most recently passed, police reform measure in Illinois. What are the good parts of that are helpful, that people are excited about and optimistic about? And where did that fall short? Or what more might we be looking for in the future out of state legislation to help here?
I think state legislation is, first of all, a tricky tool for police reform in Chicago. Chicago is very different from lots of other municipalities in Illinois in lots of ways that make kind of statewide policymaking a challenge. I do think, there's some very good things in that legislation. I think there's some mechanics to work out, including questions of home rule and so on. I just would say that by way of background, that I think, things that work elsewhere in Illinois are not necessarily entirely well tailored to Chicago.
So we're getting close to our time here. So I think what I'd like to do is just throw out a kind of big, broad question that has come up quite a bit from our attendees here, and ask you each to give a few brief remarks on how you might answer that question before we wrap it up. And the question that really keeps coming up at a couple of places here from our folks here is that, what do we think is the biggest impediment to real progress and reform here? What are the things that are really holding us back from being more successful? And if you guys could share your thoughts on that. And why don't we go ahead and just go around? I don't know who wants to go first. I am a professor of law. I will call on you.
I'll jump in.
Okay.
I'm the son of a law professor, so I'm well trained.
Good.
I think several people have touched on this. I think it really is an issue of political will at this point. And I want to come back to something Andrea said, particularly with respect to transparency, but I think there are, other aspects of change. I mean, extraordinary things have happened in these last years. So I think there's a danger in seeming like, the image was used of glacial, seeming like we're just sort of completely stuck. The image that's always occurred to me is it's kind of like swimming across a big body of water, and you're in the middle and you can't see either shore. So it's hard to judge kind of where we are. But certainly in the area of transparency, where I'm, hammering the administration as a critic, there have been extraordinary advances that we now take for granted. And I think it's, important to hold that in focus. Everything that's happened has been a product of civil society energy, of citizens pushing and political actors responding. That's really been the dynamic. And we need, yet more of that energy from that citizen energy. But we also need to have, political actors on the fifth floor, in the mayor's office, in the city council, who are prepared to really engage with that energy in a kind of process of joint problem solving, recognizing, as a number of people have said, that we are in a pretty perilous place as a city at the moment. And, the collapse of, if there's a collapse of sort of sense of possibility, and if things give way to a kind of civic demoralization now, that becomes a powerful factor in itself. So I think, I would land on the need for political will, clarity of purpose, and a sense of real urgency. It was implicit in the conversation about the foot pursuit policy. Those recent deaths didn't need to happen. Those were avoidable deaths, at the hands of the police. This is something that had been diagnosed years ago. There's a clear policy path forward. It was fixable. It wasn't fixed. We should be ashamed.
I would say two things. I think the first is a willingness to support the administrative competence of the police department. It is a large and exceptionally complex organization, and I think the department and its internal mechanisms for reform need to be administratively competent in a way that I think they are challenged presently. I think that's one thing within the department. I think elsewhere in city government, I agree with Jamie. I think there's an enormous obstacle presented by the lack of political will. And that, I think, looks like a failure to realize opportunities to sort of in a meaningful way pick up the mantle of reform. The city ought to be a proactive driver of transparency and accountability, not a reluctant subject of it. And I think until we get to a place where transparency and accountability are baked into, not bolted onto the operation of city government, we will have failed to meet the moment.
Thank you for that, Deborah. I mean, both yours and Jamie's comments sort of is reinforced by the fact that there's this recent reporting that basically says like the City Council Public Safety Committee has been kind of absent in its oversight, right? And so this idea of needing more political focus on these issues and more political will to tackle them seems like a theme that I'm hearing. Who wants to go next?
Unfortunately, I think I'm going to continue the train of
Okay.
political will. I mean,
All right.
I actually think that like leadership and accountability are the two things that we need right now. And just to put like a finer point on it, I think foot pursuits are a good example, but even the issue of wrong raids, which you asked about before, Sharon, you asked, is the current policy good enough? And it's not. Community members, including Anjanette Young herself, have worked on an ordinance that would do far more to ban no-knock warrants, to require officers to wait 30 seconds to give someone the chance to open a door, which CPD's policy doesn't do, to restrict the pointing of guns at people, including children who are traumatized by these interactions. And of course, the raid on Ms. Young is not the only one. And I just raised search warrants as well, because again, the city identified its own area of inquiry to address the public furor over what happened to Ms. Young, which happens to so many people every year, especially in Black and Brown communities, instead of engaging with communities and the consent decree. And when the coalition sought to enforce the consent decree to address wrong raids by saying, hey, city, come to the table and meet with these 14 organizations that have been involved in calling for transformations to policing, including these wrong raids, the city's response was, the word search warrant doesn't exist in the consent decree, so the consent decree doesn't apply. That's the cabined view that the city is taking to the consent decree, rather than saying we have a pattern of violence against people of color and people with disabilities that led to 3 separate lawsuits. We resolved it with commitments to make changes to promote neutral policing and policing that isn't excessively using force and engaging these patterns. Let's address this problem by using the tools that the consent decree provides to help dismantle it and create solutions. That requires leadership from the very top of the city, and that leadership is lacking in that space and in others. And then I want to switch to accountability. And I know that accountability is it's just too slow in this city. Like the fact that last summer, people were being beaten by police with baton strikes to their heads and pepper sprayed. And very few people were actually even able to file complaints because officers were covering up their name badges and star numbers, as Deborah and her colleagues have exposed, as people reported and testified to the court in the consent decree context. That is a problem. You know, not only was the CPD evading accountability, but the processes, people who did file complaints are still waiting. And that process is just taking too long. The level of community dejection that Jamie is describing is a problem as well. And it's the result of the lack of leadership and the lack of accountability that people are seeing in real time as they're calling for transformational change.
Thank you, Nusrat.
Well,
Andrea.
I'll just add to that, because I was actually not going to talk about political will, because I think COPA has, that's an issue, and I agree with those sentiments, but COPA has work yet to do, and it speaks exactly to Nusrat's final comments. We are a big linchpin in the ultimate accountability system, and we have to be faster. We have to live up to the expectations that the city has set for us. And I certainly welcome that challenge, and I know that we are motivated and galvanized in this moment to do our best work in that space. However, there are still limitations that exist outside of, COPA's ability to make its recommendations and close an investigation. That's kind of step one, sadly, in this process. So there is a lot of work to be done, but I guess what I am looking for this agency, as I lead it for the time being, is a patience of purpose. I want us to understand that this road is going to be a long one, that the swim, as Jamie said, is just beginning, but that we do need to recognize steps forward that have occurred. Because if we continue to tear down and criticize any progress, we won't get any further. But so having said that, that's sort of the focus, I think, that I'm going to make sure COPA has at front of mind as we move forward to try to deliver accountability on a timetable that is acceptable and that these issues deserve.
So Andrea, if I may, because we have had a couple of questions about this that I haven't had a chance to get to yet.
Sure.
And maybe just in this last couple minutes, because you started out by saying that COPA was to a certain extent kind of carrying with it its IPRA baggage. In your mind, could you help explain why and how COPA is different and why it's not IPRA and why we should believe that there's the potential for there to be really more independence, and integrity to the investigative process with COPA?
Sure. I mean, some of the foundational pieces to that are our independence. So meaning that the mayor can't just select the next chief administrator or remove a chief administrator that any mayor is not satisfied with. So that was a big piece. And the ordinance creating a budgetary floor, making sure that our budget was tied to CPD's budget so that, again, political whims couldn't dictate how resourced our agency was. Those are huge pieces of independence that were carved out of that ordinance, and things that we definitely hold very dear at this point. As I mentioned before, the integration of the legal analysis. If anyone takes a look at one of our use of deadly force summary reports, any of the cases, I think there's nearly 30 different officers' cases pending for separation between either DOL or the police board. That's a reflection of our last couple of years' work. Any one of those summary reports has a much more detailed legal analysis than anything you would have seen coming out of any of these predecessor agencies. Again, if you look at our domestic violence division or the cases that we've been able to take on that deal with sex misconduct, all the way up to and including sexual assault, the expertise and the analysis that are going into those cases are marked departures from what was here before. But just like CPD requires a culture shift, this agency required a culture shift. And that shift is still underway. And again, challenged by changes in leadership, challenged by extreme pressure, social and media pressure. We had a brand new investigator resign after the Adam Toledo shooting was released. And because he grew up 2 blocks from where that shooting happened and said, I can't do this work. So those are the challenges for this agency and for this time in our city.
Thank you so much, Andrea. That's really helpful. And thank you to all of our panelists this afternoon. This has been tremendously enlightening conversation. I want to thank each of you for your time here, and for each of you who were attended. We had over 100 people on the webinar this afternoon. This is reflecting the fact that this is a really important topic for our city. And so I want to thank all of you for the work you do day in and day out. I want to thank the sponsoring organizations, the Chicago Appleseed Center for Fair Courts, the Chicago Council of Lawyers, the American Constitution Society, and the Chicago Lawyers Chapter for providing this opportunity to engage with you all today. Have a lovely rest of the afternoon. And David, is there anything else that I need to cover?
No, Sharon, I think you've done a masterful job, and I want to thank you and all the panelists for a really very thoughtful and informed discussion of the issues that we're facing in trying to make progress. And I look forward to being able to talk about some more progress when we do this again next year.
Thank you all. Thanks, David.